Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's New in Mexico? The Battle for Jurisdiction Over Digital Markets. Under Mexico's competition regime, the Federal Economic Competition Commission is an autonomous federal agency responsible for competition law enforcement, policy, and advocacy nationwide. At the same time, however, an entirely separate agency, the Federal Telecommunications Institute, or IFT, has jurisdiction to enforce the competition laws in the telecommunication and broadcasting sectors. In recent years, these two agencies have sought judicial intervention to decide where one agency's jurisdiction ends and the other's begins in matters involving, for example, social media, cloud computing, and search engine markets. The Mexican Supreme Court is expected to decide the latest jurisdictional dispute between IFT and COFECE, the Commission, during 2022. Meanwhile, COFECE recently opened ongoing investigations involving digital markets, with preliminary findings expected during mid and late 2023. Joining me today is my co-host, Sarah Zhang. Hi, Sarah.
Hi, Alicia.
Sarah, would you like to introduce our guest?
Yes. So our guest today is Marta Loubet. She is a senior associate at White & Case based in Mexico City. She works in the Antitrust practice group where she advises clients through the Mexican merger control process as well as cartel and abuse proceedings. And previously, she has also worked at the European Commission in competition and regulation matters and at international and local law firms in Paris, Brussels, and Mexico City. Welcome to our Curious Amalgam, Marta. Before we start talking about today's topic, let's learn a little bit more about you. So can you tell us a bit about your path to becoming a competition lawyer?
Sure. I'm Spanish. I studied law in Spain. I really liked competition in the university. So I decided to move to Paris and further study competition. And in Paris, a teacher from my master's degree told me, "Hey, come to Brussels. There is this task force on financial crisis now in Brussels, restructuring the financial system in Europe." It sounded super excited. So I moved to Brussels and I started working at the European Commission. So that's how I started competition. Then I remained in Brussels for a few years, private practice, and now I'm in Mexico. I have been practicing competition for the last 7-8 years.
Turning to the subject of today's episode, why are COFECE and IFT disputing jurisdiction?
It all started with a constitutional reform on telecommunications and competition in 2013 in Mexico. In this reform, it was established that in the Constitution that competition policy was to be enforced via two different authorities, COFECE, which is the Antitrust Commission, and the Telecommunications Institute, which is the sector regulator that also enforces competition in the telecommunications and broadcasting sectors. And the other economic sectors correspond to COFECE. So in most cases, there is consensus about which is the competent authority for analyzing an issue. If this is not the case, then the federal law for economic competition establishes a mechanism through which the judiciary, through the specialized court, courts. There are in Mexico. There are specialized courts in competition and telecommunications. So these courts are going to determine which authority has jurisdiction over a certain matter.
Yeah. Can I just ask a question? Are these friendly disputes, or that is, the agencies just genuinely trying to figure out where the lines are, or do they tend to be very hostile and adversarial?
Yeah, I think it's a bit of both. The law is not clear, so that is where the issue starts. But at the same time, both authorities are trying to assert their powers and jurisdiction. So it has a bit of both.
So you mentioned that in most cases there is agreement, but generally, what are the types of cases in which there is typically no agreement and disputes have arisen?
Yeah, we have had a few cases lately, and I would like to talk about. And the thing is that given the growing interrelationship between the digital economy and the economy in general, the discussion on the markets that correspond to the Antitrust Authority and to the Telecommunications Authority in the digital environment is likely to continue. And something that must be mentioned is that when one of these jurisdictional conflicts arise between the Telecommunications Authority and the Antitrust Authority to resolve on a concentration, the timing for the parties to obtain a clearance decision can take, the average is like 3 months, 2-3 months, and it can take more than a year. So yeah, that's a challenge for the parties in this sector. But let me talk about a few of the most relevant cases recently. The first one I'd like to talk about is the AT&T and Time Warner merger. As you know, these companies entered into an agreement under which AT&T acquired Time Warner, and the merger triggered the thresholds in Mexico, so it had to be notified. The Telecommunications Authority argued that it had jurisdiction, as some of the markets where the merger would have an impact were under the Telecommunications Authority jurisdiction, so the whole transaction fell under its jurisdiction. COFECE, the Antitrust Authority, didn't agree with this approach, so it brought the case before the specialized courts, and the court decided that the same merger could be analyzed by both authorities. So that is the first time we have this precedent, the court saying that the Constitution allows both authorities to work at the same time in a merger authorization, and then it decided that it establishes a list of the activities that fall under the Antitrust Commission jurisdiction and the Telecommunications Commission jurisdiction. So, for instance, activities that are related to telecommunications and broadcasting but can function autonomously from such sectors fall under COFECE's jurisdiction. Product markets concerning inputs to telecommunication and broadcasting sectors are also under COFECE's jurisdiction. Another example is that when companies active in the broadcasting or telecommunications sectors develop their activities in markets different than broadcasting or telecommunications, these activities also fall under COFECE's, under the Antitrust Commission jurisdiction. So the transaction ended up being analyzed by the two authorities, and it was approved. It was conditionally cleared. And COFECE ended up analyzing the merger in the markets of some cinema licenses for exhibition, video games, etc. Whereas the Telecommunications Institute focused on broadcasting sectors. So that is an important precedent where we learned that one transaction could be analyzed by both authorities at the same time.
Did each agency do its own analysis completely separately, or was there some cooperation between them, some coordination?
Yeah, I mean, coordination in these cases is really limited. I mean, some experts in the field in Mexico think that there should be more cooperation in these cases, that there is not enough cooperation. But yeah, I mean, both are independent authorities, and therefore the cooperation is really limited in this kind of analysis.
And was that true too in AT&T and Warner then? They did their work separately?
Yeah.
Oh, okay.
Yeah, that's true.
Are there any other notable examples where this jurisdictional issue came up, and maybe where the issue of what types of markets are regulated by whom was either clarified or not?
Yeah, sure. So there's another one that is really interesting, and this is Uber and Corner Shop. Uber wanted to acquire Corner Shop. Corner Shop is a grocery delivery app in Latin America. It has like a big presence here in Mexico. So on October 2019, Uber and Corner Shop filed a merger notification before COFECE. The Telecommunications Institute considered itself to be the competent authority to review the merger, since what the Telecommunications Authority argued is that it would involve technical analysis of internet use and providers, algorithms, data centers, etc. COFECE didn't agree. And later this year, in 2019, both the Antitrust Agency and the Telecommunications Institute asked the courts to determine which authority had jurisdiction to review the merger. And so by mid-2020, after a long procedure, the court ruled in favor of COFECE. And what the court said was that Uber and Corner Shop were not telecom licensees, and that they were only using telecom services such as internet access to provide their main services through a digital platform. And therefore, the case was under the jurisdiction of COFECE. What the court said was that Uber and Corner Shop were really providing logistics and intermediary services, and the use of internet was only an input, which is neither the service that they provide nor the source of their revenues. And so this is another important precedent for determining the competences of the Antitrust Authority and the Telecommunications Authority to review mergers in the digital age. And since a lot of all the apps use the internet as input, but you have to go case by case, and most of them won't be providing their services in the telecom sector, but in, like, for instance, in this case, in the logistics and intermediary services sectors. But the court said that this jurisdictional analysis has to be carried out case by case. So we don't have like a definitive say on this. And the transaction was cleared by the Antitrust Authority at the end of 2020. So that was something I was mentioning before. It took more than a year to clear this transaction since the parties first notify it. So these cases can have an impact on the business of the parties.
Do you know if either or both agencies plan to issue any guidance, to kind of help businesses predict which agency they should be concerned about, when they apply for merger clearance? Are actors within these digital sectors expected to file for clearance with both, or do they file for one and then suddenly get surprised when the other one makes a claim?
Yeah, I mean, I'm not aware of any guidelines being prepared on this. So in general, the parties rely on the lawyers' advice. So, for instance, in the Disney Fox case, there was a double notification being filed before the Telecommunications Authority and also before the Antitrust Authority. But yeah, it's. The clients, the parties rely on the lawyers, on their lawyers' advice.
Now that a court has said it's possible for both agencies to have jurisdiction, do you expect more of a trend of filing at both agencies, or for both agencies to pick up the same matter?
Well, something that is very common in Mexico is to have in complex transaction cases, to have informal talks with the authorities. So what more and more lawyers are doing today is to advise their clients to have these pre-merger talks, both with the Telecommunications Authority and with the Competition Authority.
Now, at the same time that all of these cases have been bubbling up since the reform that you talked about, in the last couple of years, COFECE has been very active, both from an advocacy standpoint and sort of studying, and as well as their caseload in digital markets of various kinds, right? In different sectors, financial services, and as you saw, Uber. So, is that activity something that you think in some way relates to their what appears to be COFECE's view of its jurisdiction as being very broad, and is all the work it's doing with digital markets sort of an expression of that?
I mean, the Antitrust Authority taking a broad approach to define its jurisdiction is a trend that will likely follow this recent activity. I mean, in my opinion, there are some merger cases that clearly involve both authorities' jurisdiction. We have mentioned the AT&T case, and these cases should be resolved collaboratively by both agencies. But I think that when it's just an app using telecommunication services such as the internet as an input, but that is active in a different market, such as the Uber corner shop case, merger falls under COFECE's jurisdiction. But yeah, we are indeed seeing enhanced antitrust enforcement in these sectors from COFECE. I think it's a logical response to the rising importance and challenges of the digital economy.
I did want to mention to listeners that Marta is co-author of an article published on the Chamber's website earlier this year that describes the political challenges that both COFECE and IFT are currently facing. Apparently, both agencies have been functioning with fewer commissioners than they are supposed to have by law. And I wanted to ask Marta, do you think this situation has any bearing on their ability to work cooperatively in the sectors over which they have jurisdiction, or in sectors where jurisdiction is not clear at all?
Yeah, well, not necessarily. I think that the confrontations between the Telecommunications Authority and the Antitrust Authority have rather come in the past from the lack of clarity in the law and in the constitution. And also, as I mentioned before, I think it's due to a power dispute in seeking to kind of legitimize their jurisdiction. Both authorities are indeed working with fewer commissioners than they should have. And yesterday, for instance, the Antitrust Authority issued a press release saying that it couldn't decide on a barriers to entry proceeding because it hasn't the necessary number of commissioners. But I do not think this has a direct impact on the jurisdictional conflict.
For those of us who aren't as familiar with Mexican politics, why is it that these agencies have less than a full complement of commissioners?
Well, both the Telecommunications Institute and Antitrust Commission are autonomous bodies. They are independent and they are a counter power to the power of the government. The thing is that the commissioners have to be appointed by the government. So the way the government is trying to get rid of both authorities is by not appointing new commissioners. So that's what's going on. There is like this procedure whereby the candidates go through exams, their CVs are examined, and it all is done by the commission, by the institute, and by other organs, and that has been done. And the candidates have been proposed to the government. So now it's up to the government to carry out this final step and appoint them. But the procedure is blocked at this phase. They are they don't want to appoint these commissioners that are missing in both institutions.
Well, it's a credit to them that they're getting anything done at all. Those are difficult circumstances.
Absolutely.
Yeah. Well, this has been a very interesting conversation. I'm sure we've just scratched the surface. I do want to let listeners know that we'll post a link to Marta's article on the webpage and to the COFECE and IFT webpages too, for anyone who wants to dig deeper. But before we let you go, Marta, we're going to ask you the question that we ask all of our guests on our Curious Amalgam, because we're curious to know what's something interesting about yourself that is outside of your professional life.
Sure. I think that something that is interesting about myself and that is also related to the first question about how I get to become an antitrust lawyer is that I studied art history. I specialized in contemporary art, and I was working at a gallery in Madrid where I was 20-something, and I was wondering whether I wanted to pursue this career in contemporary art. And the collector told me, you like business world, you speak languages, why don't you go to Paris or London and studied competition law? So that's what I did, and so I have this past in the art world that not a lot of people know about. So
yeah, that's interesting. And finally, for the last segment in the show, we're going to ask you to play the little game that we ask everybody to play. That's called The Curious Hat.
And now it's time for The Curious Hat!
The game is very simple. Sarah is going to pull a surprise question out of our virtual hat and read it to you. Go ahead, Sarah.
All right. So the question that the hat has produced is, what is your idea of a perfect weekend? How would you spend it?
I think I'd spend it in nature, with my dog, friends, or family. So during the weekends, I try to unplug as much as possible and be in nature.
That does sound relaxing. Well, I hope you and Sarah and all of our listeners have an equally relaxing weekend one of these days. Thank you for listening and join us next week.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.